Good afternoon, and welcome to Employee Rights in North Carolina, presented by Legal Aid of North Carolina. At today's clinic, we will discuss employment at will, right to work, employment discrimination, wage claims, and unemployment benefits. Let's get started. There are many federal and state employment laws which protect some employees from illegal treatment by their employers. Today's clinic will explain your rights and possible remedies under some of these laws. However, it may be difficult to prove a violation of these laws in court. You should try to consult an attorney specializing in employment law before complaining to your employer about your treatment or taking legal action against your current or former employer. North Carolina, like many other states, is an employment at-will state. This means that a private employer can usually hire, refuse to hire, or fire an employee for any reason, unless that reason is illegal under federal or state laws. Employees of federal, state, or local governments and employees protected by union contracts may have additional rights. Often, nonprofit corporations have grievance procedures that offer employees additional protections. Many employees are protected by the National Labor Relations Act, which may prohibit employers from disciplining employees for discussing wages, hours of work, and working conditions. For more information, contact the Winston-Salem office of the National Labor Relations Board, NLRB, at 336-631-5201 or visit the NLRB's website at nlrb.gov. If an employee works at a job covered by a union contract called a collective bargaining agreement, the employer must follow the terms of the agreement. North Carolina is a right-to-work state, which means that if a union wins an election to represent you and other workers, you cannot be required to join the union and pay union dues to keep your job. The union is required to represent you and allow you to file grievance complaining about your treatment, even if you do not join the union or pay union dues. Now, let's talk about what type of employment discrimination is against the law. Under federal laws, an employee is protected against discrimination on the basis of age, which applies to workers over the age of 40, disability, sex, which includes sexual harassment, pregnancy, ethnicity or national origin, race or skin color, genetic information, religion. The federal law protects most federal, state, and local government employees, and many employees of private employers with 15 or more employees. The protection against age discrimination requires that the employer have 20 or more employees. If you believe that you've been discriminated against by your employer, you may file a complaint with the Equal Employment Opportunity Commission, or EEOC. The EEOC is a federal agency that investigates claims of employment discrimination. You must file your complaint or charge within 180 days from the date of the last incident of discrimination. The EEOC will conduct an investigation. In some cases, the EEOC will represent the employee in his or her claim against the employer. After the EEOC completes its investigation, if it is unable to assist the employee further, it will issue a notice of right to sue, which allows the employee to file a discrimination lawsuit against the employer in court. The employee must file the lawsuit within 90 days after receiving the notice of right to sue. You may file a complaint with the EEOC by contacting 1-800-669-4000. You may obtain more information at their website, eeoc.gov. The website will help you find the EEOC field office closest to where you live. North Carolina has EEOC field offices in Charlotte, Greensboro, and Raleigh. The North Carolina anti-discrimination law is called the Equal Employment Practices Act, or EEPA. It also prohibits discrimination on the basis of race, religion, color, national origin, age, sex, or handicap. Like the federal laws, it protects employees of private employers who employ 15 or more employees. Here are some examples of workplace discrimination. Being fired or having your work hours cut because of your race or sex. Being denied promotions or transfers because of your age. Being taunted or harassed by your coworkers because of your religion. North Carolina law also protects employees against retaliation in the workplace. This law is called the Retaliatory Employment Discrimination Act, or REDA. REDA prevents an employer from retaliating or discriminating against an employee who enforces his or her rights. The employee's rights protected under REDA include the right to receive workers' compensation, the right to receive minimum wage, the right to report dangerous workplace conditions. REDA also protects employees from discrimination who serve in the National Guard, have the sickle cell trait, are hemoglobin C carriers, participate in juvenile justice proceedings, participate in genetic testing, are domestic violence victims, report drug activities by their employer. To file a discrimination complaint under the North Carolina REDA, you may contact the Employment Discrimination Bureau, or EDB. The EDB is part of the North Carolina Department of Labor. You may contact them at 1-800-NC-LABOR or 919-807-2796 or visit their website nclabor.com/EDB. You must file your complaint within 180 days of the date of the employer's most recent discriminatory or retaliatory act. Like the EEOC, the EDB will investigate your complaint. If it determines that your complaint is valid, it will try to resolve or settle the complaint on your behalf. If the EDB is unable to resolve the complaint, it will issue you a notice of right to sue. You must file your lawsuit within 90 days of receiving your notice of right to sue. Under both federal and North Carolina law, if you are able to prove discrimination, you may be reinstated to your previous position or its equivalent with retroactive seniority and benefits. Recover back pay. Receive promotions. Be awarded money damages. Some types of activities are not protected unless prohibited by an employment contract or labor union collective bargaining agreement. For example, an employer may change your workdays or work hours. An employer may change your job description or responsibilities or assign you extra duties. An employer may require you to work overtime. An employer may treat you differently from your coworkers. Unless the reason for the different treatment is discriminatory as defined by the law. As we stated earlier, You should consult with an attorney specializing in employment law before complaining to your employer about your treatment or taking legal action against your current or former employer. Your attorney may recommend that you keep at your home a written record of any unfair or illegal treatment by your employer. You should print copies of your pay stubs if you're paid by direct deposit, and keep copies of any evaluations or disciplinary warnings. You should not keep any personal confidential information in your employer's provided computer, desk, or locker. Another federal law that protects employees is the Family and Medical Leave Act, or FMLA. FMLA allows an employee to take up to 12 weeks of unpaid leave for a health-related reason and still keep his or her job. FMLA applies to employers who have 50 or more employees. It also applies to federal, state, and local governments, regardless of the number of employees. The law allows an employee to take unpaid leave for his or her own serious health condition, or the serious health condition of a spouse, parent, or child, as well as for the birth or adoption of a child. A serious health condition is an illness, injury, or physical or mental condition that involves an overnight stay at a hospital, hospice, or residential medical care facility, or continuing treatment by a healthcare provider. In order to be eligible for FMLA leave, the employee must have worked at least 1,250 hours for a minimum of 12 months for a covered employer. 1,250 hours averages about 25 hours per week. An employer can require an employee to use his or her paid leave before taking leave under the FMLA. When the employee returns from FMLA leave, he or she is entitled to be reinstated to the job that he or she held at the time he or she took leave, or to a similar position with equivalent benefits, pay, and other conditions. The law also provides additional rights for eligible employees who need to take leave to care for a family member who is a covered military veteran with a serious injury or illness. This type of leave is called military caregiver leave. It allows an eligible employee to take up to a total of 26 work weeks of unpaid leave during a single 12-month period to care for the veteran. An eligible employee must be the spouse, child, parent, or next of kin of a covered veteran with a serious illness or injury. A covered veteran is a veteran who was a member of the armed forces, including the National Guard and Reserves, was discharged or relieved from service under conditions other than dishonorable, was discharged or released within 5 years of the date the eligible employee first takes military caregiver leave, has an injury or illness that was incurred by the veteran in the line of duty while on active duty, or that existed before the veteran's active duty and was aggravated by service in the line of duty while on active duty. If you believe your rights under FMLA or your right to take military caregiver leave has been violated by your employer, you may file a complaint with the United States Department of Labor, Wage, and Hour Division. There are 2 offices in North Carolina. You may contact the Raleigh District Office by calling 919-790-2741 or the Charlotte Area Office by calling 704-749-3360. You may also call either office toll-free at 1-866-487-9243. More information is available at wagehour.dol.gov. Let's talk about wages and vacation pay. The Fair Labor Standards Act, or FLSA, establishes minimum wage, overtime pay, record-keeping, and youth employment standards for employees of private employers and federal, state, and local governments. The United States Department of Labor enforces the FLSA. Most North Carolina employees are entitled to receive the federal minimum wage. The current amount of the federal minimum wage is available at dol.gov/MINIMUMWAGE. If you work more than 40 hours in a week, you may be entitled to receive overtime pay, which is your regular hour plus 1/2 of your regular hourly pay. An employer is not required to provide paid leave, either for illness or vacation. If you leave your job for any reason, your employer must pay you any earned pay or vacation time. Any earned wages must be paid to you on the next regular pay day after your last day of work. If you believe your employer has violated your rights under the Fair Labor Standards Act, you may file a complaint with the United States Department of Labor Wage and Hour Division. You may contact them by calling 1-866-487-9243 or visit their website at dol.gov. If your employer has not paid you as required, you may also contact the North Carolina Department of Labor's Wage and Hour Bureau. You must wait at least 10 days from your last payday before asking for help. You may contact the Wage and Hour Bureau by calling 919-807-2796 or 1-800-NCLABOR. That's 1-800-625-2267. Their website is labor.nc.gov. If your former employer refuses to cooperate, the Wage and Hour Bureau may not be able to help you. If that happens, you may file a complaint for money owed against your former employer in small claims court. A free guide to small claims court is available on Legal Aid of North Carolina's website at legalaidnc.org or from the Office of the Clerk of Superior Court in each county. If you want assistance from the Wage and Hour Bureau, you must apply for help before you file a complaint in small claims court. After you file your complaint, the Wage and Hour Bureau will not be able to help you. You should consult with an attorney before filing an action in small claims court to determine what evidence you will need to present in court and the likelihood of collecting on any judgment you may receive. If you retain a private attorney to represent you, your former employer may be ordered to pay your attorney's fees. Finally, let's talk about unemployment insurance benefits. To obtain benefits, an employee must file a claim with the North Carolina Division of Employment Security, or DES. After filing the claim, the individual, called the claimant, must register for work. Once the DES receives the claim, it will determine if the employee is eligible for benefits. To be eligible for unemployment insurance benefits, the claimant has to be able and available for work and have been paid wages by the employer over a defined period of time, called the base period. Claimants who worked for certain types of employers or performed certain types of work are not eligible for unemployment insurance benefits. In addition, claimants who worked as independent contractors may not be eligible for unemployment insurance benefits. Once the DES establishes that a claimant is eligible for benefits, it will determine if the claimant is qualified for benefits. Whether a claimant is qualified for benefits depends on the reason why he or she was separated from his or her employment. If a claimant is terminated from his or her job, he or she may be able to receive unemployment benefits. While it's true that an employer can fire an employee for any reason, apart from the exceptions we've already discussed, the reason for the termination determines whether the claimant is qualified or disqualified for unemployment benefits. If the employer fired the claimant for misconduct, the claimant will be disqualified or barred from receiving benefits. Misconduct is a legal term. North Carolina law defines misconduct as behavior by an employee that shows a disregard for the interests of the employer. Misconduct can also occur when the employee violates an important policy of the employer. Examples of misconduct can include threatening a coworker, disobeying a directive from a supervisor, failing a drug test, or taking unexcused absences from work. If you work for a private employer, your behavior at work and your personal relationships with your supervisors are often as important as your attendance and the quality of your work. If you disagree with a warning that you've received for making a mistake or violating a rule or policy, and your employer gives you the opportunity to explain your version of what happened, then you should briefly explain why you disagree with the warning. However, even if you disagree with the warning, it is rarely productive to pursue appeals of the warning up the chain of command. Sometimes it is better to acknowledge the mistake or violation than to contest the warning and challenge your supervisor. If you are told by your supervisor that you're being fired for a mistake that you made or for other personal conduct, you should consider asking for the opportunity to resign, which will make it easier for you to obtain work with a different employer. When you reapply for work, you will be asked why you are not employed. It is easier to explain a resignation than a discharge. If you resign after being told that you're being fired, your resignation will usually be treated as a discharge if you explain why you've resigned when you apply for unemployment insurance benefits. Someone who resigns his or her job may be disqualified for unemployment benefits unless DES determines that he or she resigned with good cause, attributable to the employer. Good causes may include a permanent reduction in work hours of more than 50% of the customary scheduled work hours where the individual is employed, provided the reduction was not caused by the conduct of the individual, or a permanent reduction of the individual's rate of pay of more than 15% provided the reduction was not caused by the conduct of the individual. Another example of good cause attributable to the employer is an employee that resigns his or her job because of harassment from coworkers that the employer refused to address. If you work for a temporary employment agency and your job assignment ends, you must immediately report the job loss to the agency and follow the agency's rules to report your availability for other work. You will not be eligible for unemployment insurance benefits unless the temporary agency has no other work for you. If you apply for unemployment benefits and are denied, you should consult with an attorney right away. You have only 30 days to appeal the initial denial. If you are approved for benefits, your employer also has the right to appeal. Again, you should consult with an attorney right away if you receive notice that the employer is appealing your award of unemployment benefits. If the employer is successful with its appeal, you may have to repay the benefits you received. To file a claim for unemployment benefits, you may visit your local office of the Division of Employment Security. For additional information, call 1-888-737-0259 or visit their website, des.nc.org. You may receive a maximum of 13 weeks of benefits. Remember, you must be actively searching for work and reporting your work search while you're waiting for your claim to be decided. You must continue to look for work and report even after you are approved for benefits. If you are disqualified for benefits and appeal your disqualification, you must continue to actively search for work and report your work search while you remain unemployed. If you need further assistance, you may contact Legal Aid of North Carolina toll-free at 1-866-219-5262 or visit legalaidnc.org. If you would like a referral to a private attorney, you may contact the North Carolina Bar Association's Lawyer Referral Service toll-free at 1-800-662-7660. If you're calling from outside of North Carolina or are using a cell phone with a non-North Carolina area code, you will need to call 919-677-8574. The Lawyer Referral Service can connect you to a private attorney who will charge you $50 for a 30-minute consultation. This concludes our presentation this afternoon. We hope you found it helpful.